to introduce to you our guest speaker, Shlomi Levi.
All right. Good morning, everybody. Thank you so much for coming over and coming out this morning. I heard there's some traffic, so I'm glad everybody's here. A big thank you to Shirley, your team, the entire team at JCF and CPL for putting this together. You guys all saw my bar mitzvah picture, so I hope I didn't change too much. The reason I'm able to stand here today is because we have a very unique outfit in terms of our practice. We got offices in different places, and Montreal, Toronto, Fort Lauderdale, and Tel Aviv, and we have actually local attorneys in every one of these offices, allowing us really to embrace the opportunity to not only analyze and assess the situation, but advise and also implement. So a lot of the information I'm going to give you today is, I would say, generic in the sense that it'll try to catch as many fact patterns as possible. However, if you have specific questions, please don't hesitate. I have a very simple policy on questions. The easy ones I'll answer. The hard ones we'll keep till the end, and then I'm going to leave. All right? So I'm going to try to make this as interactive as possible. But honestly, feel free to ask questions. The world has changed. We get comments, questions about owning in the U.S., moving to the U.S. The borders are pretty much erased in terms of where people are citizens of. Residency is shifting pretty much on a daily basis. People are working from home in Florida. People are working from home in Tremblant, and they're Americans. So the lines are really blurred, and it's becoming a challenge for professionals. It's becoming a challenge for the governments. It's becoming a challenge for everybody. And I'm going to try to untangle some of the key elements. There's a lot of misinformation out there about the famous U.S. estate tax. There's a lot of planning that is worthy. There's also a lot of planning that's very heavy on the compliance side. And so, we'll try to just give you some clarity about it. One of the main points of entry for Canadians into the U.S. is real estate. And so typically choosing an ownership structure will be kind of the first elements to visit. Obviously, the easiest way to own title is in one's name. And you go into the U.S. and there's comments or titles like jointly as tenants in common or joint tenancy with right of survivorship. We live in a civil system. We're not really familiar necessarily with these terms, but there's all kinds of strategies to avoid one very key element in law, which is probate. In Quebec, we have a Quebec notary. They're supermen. They have superpowers. Their documents are deemed to have been homologated by the courts, and therefore, something happens. You go to your Quebec notary, and they've got the powers to sign documents, and those documents are deemed to have been homologated by the courts. No probate. You get to places like Florida, and I'll use the term Florida a lot, only because we have an office there, but probate happens pretty much everywhere except for Quebec in North America. And you get to Florida, and probate is an extremely difficult process. And we'll talk about it in a few minutes, but you definitely want to avoid it. So simple in your name does bring up issues associated with the ownership. And you'll find out, and some of you may be already familiar with it, there's a lot of chatter around the pool in a clubhouse on how to beat probate. And we'll talk about that as well, but you've got many strategies that are, on the face of it, look great. But when you start digging in, you realize that they create all kinds of issues, tax obligations, tax filings, and a lot of tax money at the end of the day. The U.S. is really big on trust. I've just only put 4 on the screen, but there's about 20. And choosing the right type of trust for you will be instrumental in making sure you don't get caught. And I'll say this a lot today, but one of the main focuses when you're doing some tax cross-border wise is to avoid the dreaded double taxation. We want to make sure we don't pay more tax than we need to. And often enough, when the structures don't align, there's a mismatch, you'll pay twice. So we want to make sure to avoid that. what's becoming more and more popular for Canadians is to doing a lot of investing in the U.S. And I see a few people in the room that I've worked with that are involved in these types of these projects. And partnerships are growing to be more and more popular for a very, very simple reason. They actually work for the first time. There's a lot of stuff that doesn't work for Canadians, but partnerships do. So we'll look at that a little bit later. And then the famous corporation. Canadians love to have their money in corporations. They raise capital. They only pay tax on what's being used. Retained earnings sit there, non-taxable. But on the U.S., the rules are completely different. And if you have a Canadian corporation with a U.S. beneficiary, for instance, issues arise. You have a Canadian corporation doing business in the U.S., you've got issues. You've got an American corporation doing business in Canada, you've got issues as well. So we'll talk about the issues on the other side of the border for mostly today, but the truth is it's also the same in Canada. So without any delay, let's talk about some scenarios that I was able to put together just to give you a sense of the issues arising in the U.S. So this scenario reads as follows. We bought a condominium in Florida for $300,000 and put the title in my husband's name alone. Everything was fine until he passed away. After that, I couldn't sell the property because the estate was frozen. Probate took over a year and cost between $10,000 and $15,000. So show of hands, how many people in the room think that your Quebec will is valid in Florida? Right. Common sense says it's not valid. The reality is that your Quebec will is valid in Florida. In fact, it's valid anywhere in the world because of the fact that it's valid in Quebec. That doesn't mean that it's going to take the form and going to eliminate some of the issues arising with settlement of estates. As I mentioned, probate in the U.S. is a very time-consuming, completely public and expensive procedure. If we just use Florida, for instance, and the tri-counties where most Canadians are, Palm Beach, Broward, and Miami-Dade, probate could take anywhere between 24 to 36 months today to complete. And we hit a bit of a glitch because there's no probate in Quebec. You go to U.S. courts and they expect you to come up with some sort of a probate judgment from your jurisdiction, and we don't have one. So go explain a judge in Texas why in Quebec we don't have probate. So that's the first difficulty. The second difficulty is that everything's public in the U.S. In fact, those of you that own property in the U.S. could Google your name or your address, and Google will tell you who you bought from, what you paid, what's your home address, what's your mailing address, and sometimes it'll even have a phone number. So you definitely don't like to be involved in these procedures. Cost. If we're talking Florida, there's a Florida statute that regulates probate and calls for a 3% fee on the fair market value of the asset at time of death. And that's before cost and disbursement. So you can round this off to about 5% of the value. 300,000, we're talking about 15,000, but as the property values keep growing and growing in the U.S., those probate fees are increasing. And you don't want to be caught in one of these in a foreign jurisdiction. A lot of our clients here in Quebec have wills in French. Try to post a Quebec French will with a Florida court. Not fun. Now, as I mentioned, there's a lot of chatter about how to deal with these things in the U.S. And typically, you go to a U.S. lawyer who's strictly practicing on the U.S. side, and you say, well, we just bought a home, what can we do? And they like probate. Probate is licensed to make a lot of money in the States. So they don't necessarily will take you through a strategy that will avoid probate. They'll tell you, just draft a will. And the slide came about from a file I dealt with about 6 or 7 years ago. The client was in his 70s, a former Quebecois who moved to Toronto and was divorced with 3 kids. Net worth was approximately $50 million. Went down to Florida with his second wife, brand new bride, purchased a very modest $500,000 condo, and speaking to the lawyer, the title lawyer said, look, we're from Canada, what should we do? And the suggestion was to have a Florida will drafted. Everything's fine. Will's drafted. Everything goes well. Unfortunately, the client passed away, sends his new bride to my office to say, my husband said to come see you in case something happened. We have a condo in Florida. And to my astonishment, I read the will, and what is the first clause in every will? Anyone? I hereby revoke any and all prior wills executed by me. So we had a will done for him, accounting for the $50 million, going to his three kids in trusts and all, in equal shares. And here we go. We have a will that cost him $500 that practically transferred 100% of his wealth, including the Florida condo, to his new spouse. And what happened then is that it turned into a court case, which nobody likes. And fortunately, there's a happy ending to this. The bride accepted to split with the kids, which was the right thing to do, but not necessarily the logical thing to do. So for me, it's very important that when we do deal with these questions, have somebody that has the knowledge, the how. A very simple solution would have been to create what we call a situs will, where you just say, this is my will for my U.S. assets. Not that it avoids probate, but it doesn't matter. My will for my U.S. assets shall not be revoked by any Canadian will or revoke any Canadian will. And having two standalone documents would have simplified things. But we're not in a simple world, and we don't control other professionals. So we try to control our clients and our needs personally when looking at this. So always beware, because that wasn't a fun activity, scenario to deal with. It wasn't a fun file to deal with. And it could have been avoided by simple consultation with somebody who had the means to help. Incapacity. So a lot of people are worried about what happens when we die. I think that with today's advancement in health technology, people live longer. But unfortunately, people also lose capacity. And that's actually worse than passing away. And people don't recognize it. So this scenario reads as follows. My parents own a condominium together in Florida, but they can't enjoy it anymore since my mom developed dementia. My dad couldn't sell the property because of my mom's condition, and so we had to do a costly and time-consuming Florida guardianship procedure. So we know that your Quebec will is valid. How many think that your Quebec power of attorney or incapacity mandates are valid in the state of Florida? Right, so that's a trick question, Shirley. So although your Quebec will is valid, the incapacity or protection mandate, as it's called here in Quebec, is a Quebec-specific document and is not valid in the state of Florida. In fact, it doesn't even respect the execution rules in the state of Florida because you don't have two witnesses. And so what happens is that people don't necessarily pass away, they become incapacitated, and then you're stuck. The asset is frozen, and you got to go through a very expensive procedure. This one is not regulated by a statute, and therefore no tariffs are available. And so it becomes complicated. Just like in Quebec, you need to get psychosocial analysis, you need to get a medical report, but everything is stretched out in Florida. So we want to avoid those situations because the asset gets frozen. Typically people realize that, I'm dealing with a case where the parents are selling, the father is a little bit tired, they don't travel to Florida anymore, insurance is too expensive, can't really transfer the property because of the incapacity. And now you've got a property that's draining you from the upkeep perspective. You want to try to put it up for rent, you can't put it up for rent. And what happens then is that you're just being drained and it puts a lot of stress on the family. So again, incapacity, big issues. Here again, you may need, you may not may. You will have to settle the incapacity in the country or province of residency first. So you will need to get an homologation here in Quebec before we can take that down to Florida anyways. So the process gets stretched even longer and very expensive. Here's one I really like. Protections for your beneficiaries. So parents work hard. They set up their plan. They want to make sure that their assets go down to kids and grandkids. and life gets in the way. And I've got a few examples here. Scenario reads as follows. We are worried about what happens to our kids after we pass away. What if my son or daughter inherit my $300,000 house in Florida, and then their business goes bankrupt? Can their creditor seize the asset? Also, what if his wife divorces him? Will she get 50% of the property? So these are very legitimate questions. So remember I said something about chatter around the pool or the clubhouse. And we just spoke about probate and incapacity, and they're annoying procedures. In Florida, there is a thing called Lady Bird or life estate, which is pretty much the equivalent of Quebec usufruct, where you own something and then you transfer the ownership to this Lady Bird deed, and now effective ownership is vested in the hands of the kids, but the parents get to maintain usage of the property during their lifetime. So this is a very big deal in Florida. A lot of people recommend it be done. And the reason to do that is you assume that by putting your kids on title, you're going to punt down the line the probate and incapacity question. And from a legal technical perspective, that's actually absolutely right. You move the property over to the kids, hopefully nature takes its course, parents have issues before kids do, and then you've punted that problem down the line. But let's look at it from a tax perspective. What happens? And I'm going to use a very common example. Mom and dad purchased the property in 2010, the height of the crisis, call for $200,000, and the dollar's at par. Fast forward to 2023, that same unit is worth $600,000, and the dollar is at what, 30, let's just say 35% for the sake of this conversation. So we've got a cost basis of $200,000 US and Canadian, and we've got a $600,000 US, and 6 times 3, 180, about 210, so about $800,000 in Canadian dollars. And following the advice of a friend by the pool, they decide to either add the kids or do a Lady Bird deed. Well, from a U.S. perspective, here's what just happened. Under U.S. tax rules for non-residents, there's gift tax. There are exemptions, very tiny exemptions in the system, about $17,000 based on inflation today. Anything above that is taxed at a rate that goes between 18 and 40%, with the 40% benchmark hit coming very, very fast at you. So mom and dad each gifted 25% of their ownership to their 2 kids. And so we've effectively gifted, $150,000 times 2, $300,000. Reduce your $34,000 exemption. The balance is going to be taxed at 40%. Let's look at it from a Canadian perspective for fun. In Canada, most of these properties are typically secondary properties. They're not your primary home. So although the action of making a gift in Canada is tax-free. I'm looking at Joel here, just celebrated his 50th birthday. Happy birthday, Joel. If you choose to give me $1 million, that gift is free. Don't hesitate anytime. I'll send you wire transfer instructions. But when you actually make a gift of an asset, although the action of the gift is tax-free, the asset itself is subject to a disposition because it's not your primary home, it's not exempt. And so in Canada, when mom and dad made that gift, although the action is tax-free, the asset itself is taxable, subject to capital gains. Current rate, over $200,000, 26.5%. So we had a cost basis of 200 Canadian. Canada likes to also calculate the exchange rate when they tax you. And we have an $800,000 fair market value. It's effectively a $600,000 disposition at 26.5%. Figure it's about $150,000. Now, Canada and the U.S. have an amazing tax treaty that works to avoid double taxation. And the criteria is that you need to have a match in the type of tax, the taxpayer, and the year. Well, here we have a problem. We've got gift tax on one hand, and we've got a deemed disposition that triggers capital gains on the other. Quickly doing the math, we're probably looking at somewhere like in the vicinity of $300,000 of tax. All this because somebody by the pool suggested that we avoid probate that on this scenario would have cost, what, $25,000 in the best of scenarios? So we have to be extremely careful. A lot of people also will take the advice to add their kids onto title. Not doing a ladybird or not doing a life estate, simply adding their kids onto title. And the same thing happens. And now you're now including the scenario where their creditors could come and seize the asset. Or, mom and dad get a phone call from their son and says, hey, mom, my wife just called me and she said she doesn't love me anymore, but she'd love to take 50% of all my assets, including your condo in Florida. Not a fun call to receive. So we want to make sure. Now, you're wondering, why would anybody in the U.S. make such a recommendation or give this advice? Oh, it's very simple. Americans have a lifetime gift tax exemption currently at $12.9 million. So any Americans in the room? Okay, there you go. Well, Joel could give me $1 million. You can give me $12.9 million without any tax. So for an American attorney, what's $300,000 or $400,000 when you've got $12.9 million exemption? So the advice is very loosely given. I like to say that Americans in general, and lawyers more particular, are very, very centric about the states. I'd like to say that you give an American lawyer a piece of paper and a pen and ask them to draw a map of the world, they draw the United States and water all around it. Nothing else exists. And so we can't really go after them, blame them. We just have to roll with the punches on these things. So what are certain solutions? What can we do to maybe avoid probate? What can we do to avoid the pitfalls? What can we do to make sure people don't create scenarios where they're going to get taxed or double taxed just trying to plan? Excuse me. The following scenarios that I'm going to describe are just some options that are available out there. They don't fit everybody, but they will provide relief. So some of you may have heard the term cross-border trust. Cross-border trust is really an estate planning tool. It's not a tax planning tool. It's not a trust, really. Under the U.S. rules, this is what we call a revocable trust. In Canada, this would be the equivalent of a bare trust contemplated under Section 104 of the Act. But really, it's not really a trust. It's a flow-through entity. And the way these types of trusts need to be drafted is that they need to be active enough from a U.S. perspective to help avoid probate, and they must remain passive enough to qualify as bare trust so that the asset is deemed to belong to the individual settlor and beneficiary. Now, what's great about these documents is that you can put them in place at any given time, provided they respect the acts. You're not going to trigger any disposition. So even though your property was purchased for $200 and is worth $600 today, you can still roll over your property into these types of trusts. And the sole purpose of having those trusts in place is to avoid issues associated with probate and incapacity. I heard a lot of people in the community, in the tax community, say these taxes don't help with U.S. estate tax. They don't. They're not there for U.S. estate tax reasons. They're there for probate reasons. They're there to find an alternative to the ladybird and to the adding your kids to title, etc., while avoiding probate. And what's great about them is because those documents or those trusts aren't separate legal and tax entities, the individual pays the tax and it allows to maintain that match on foreign tax credits, avoiding double taxation in the event of a disposition or in the event that there's rental income coming from that property. A lot of our clients, a lot of your clients, a lot of people in the country deal with higher level values of properties, higher level values of estates, and sometimes they have a need for creditor proofing for many, many reasons. Sometimes their wealth is sitting in structures that doesn't allow personal ownership. So a cross-border irrevocable trust would be the equivalent of a Canadian family discretionary trust. Now, some people will use a simple family trust to own property in the U.S., And unfortunately, from a U.S. perspective, those would be nothing other than grantor trust, which will be the equivalent of a regular revocable or cross-border trust without any U.S. estate tax benefits or protections. But where a properly crafted irrevocable trust is put in place, you're able to avoid a lot of things, such as probate and incapacity. If the only asset in the structure is the property, then you're also created a very good creditor-proofing mechanism. Being the same taxpayer on both sides of the border will help prevent double taxation. But here's the caveat. There's a 21-year disposition rule under Quebec tax rules and Canadian tax rules. Quebec also has the independent trustee rule, that now you need to have a third party pretty much managing your asset, and you're good in the U.S. And the caveat, the biggest caveat in my opinion, is that you can't just do rollovers into these types of structures. You need to worry about how to get it into the trust if you've already owned it and the price appreciated. You're going to trigger a disposition. In Quebec, or in Canada more particular, we have another issue. These trusts come to an end at the end of 21 years, as mentioned. And most strategies today is that you either take the asset in the trust and distribute it to the beneficiaries, meaning that you've effectively gotten rid of your assets during your lifetime, or most trusts will contemplate the distribution to another trust being formed. So in Canada, that happens pretty naturally. What happens in the US? How do you change title without triggering gift or tax? So there's a debate. I was at a STEP conference this week, and there's a question about it. Article 13 of the treaty contemplates a certain leeway in trying to move these properties, but it will require some bumping up of cost basis, typically accompanied by tax in the US. So we have to be very careful. So these types of trusts are being used by the big firms, mostly when US estate tax is in play, but they do create challenges that not everybody knows how to deal with. Corporations they're great. In Canada, we like our retained earnings. Corporate rates are low, individual rates are high. So we want to stay on the side of paying as very little tax as possible. So when your property is titled in the US into a corporation, of course, a company never dies. A company never becomes incapacitated. So we don't have to worry about these things. When a company doesn't die, it also isn't subject to US estate taxes, except in very, very unique situations. And obviously, if it's properly crafted, you'll have creditor protection. However, Canada, as of 2005, eliminated the sole purpose corporation principle, where you could own assets in a sole purpose corporation and not be tagged with a benefit rule. So that kind of went out the door in 2005. And what it means is that when a company owns a property and the shareholder actually uses the assets of the company, he or she are assessed a taxable benefit rule equivalent to the cost of operating that and owning that property. And typically today, people will use, in some cases, they'll use the corporation to avoid US estate taxes. But what happens is when you're tagged with shareholder benefit rule over, let's say, a 20-year period, you've pretty much surpassed the cost of what might be a US estate tax bill in the event of death. So, not crazy about it. You'll hear a lot of Canadians talk to you about limited liability companies, LLCs. And that's pretty much the fallback position on the US side. You speak to anybody, what should I do? LLC. Well, LLCs cause double taxation problems. And we'll see it in a couple of slides. Well, this slide. This slide actually shows you the tax exposure on the US side. This is just capital gains and this is just federal. And the reason it's only federal, Florida doesn't have an individual tax rate. But when you look at trusts, limited partnerships, personal ownership, you're looking at the lowest tax rates. Typically 0 to 500,000 of gains, or 600 for married couples, is taxed at a progressive rate capped at 15%. Anything above that will be taxed at 20%. And we know that in Canada, Capital gains, anything above $200,000 will be 26.5% in Quebec. So if we're able to create a mechanism where we are not double taxed and utilize foreign tax credits, your Quebec rate will always apply. You're just paying it to two different jurisdictions. You'll pay 15% to Florida, another 11.5% to Quebec, and we're good to go. Corporate taxes in the US is actually different. It's a flat corporate tax. There's no distinction between capital gains and income. And what happens is that you're paying the tax, and Florida actually has a 5.5% corporate tax, state corporate tax. So if you own a property in a corporation, you're going to get a 26.5% tax hit on the US side. Now, if the company has a Canadian shareholder, the money absolutely must be reported in Canada and therefore pushed up to Canada for an intercompany dividend of 5% gross or 3.5% of the net. So you're almost at 30%. Now, if you try to poke the money out of the corporation in the US, you're going to pay about 26.5% in the state of Florida on dividends as well. To be precise, 25.5%. And if you try to poke that money out of Quebec, you're going to pay about 44%. You start doing all this math, and you're spending 65, 70% when you own it in a corporation. So we want to stay away from corporations for estate planning or corporate planning purposes, but sometimes you have no choice because your money's sitting there, and then we try to play the treaty with corporate entities flowing up and down. But look at the LLC. The LLC causes double taxation, and here's why. An LLC, a limited liability company, or a limited liability partnership, or a limited liability limited partnership, as they're known in the US, are all disregarded entities. The individual member or partner is the taxpayer. And so if you've triggered a gain in one of these, you're paying tax individually, you get that 15% tax rate in the state of Florida, and no Florida tax due. But from a Canadian perspective, we don't have an equivalent of an LLC. And in Canada, if it looks like a duck and quacks like a duck, guess what? It's a corporation. And so Canada will view your LLC as a foreign affiliate. And in Canada, you'll pay tax as a foreign affiliate, and you'll pay that 26% dividend rate after credits and discounts. And remember what we said about the treaty a few minutes ago. You need to have a match in the type of tax. On the US side, we have simple capital gains or income tax. In Canada, we have a dividend from a foreign affiliate, double taxation. So we want to stay away from these. We absolutely want to stay away from these. LLC will cost you 46%. And now, since Canada consider your foreign affiliate as a corporation, you may even have to deal with more extraction problems as you pull the money out. So we definitely want to stay away from LLCs. A lot of our Canadian clients are also buying now because they want to rent their properties. They have investment properties they want to rent. One tip that I'll give everybody, the slides, by the way, are going to be made available by the team for those who registered, so you get a copy. But a lot of people don't know this. In the US, when you rent your property, you have to pay tax on your gross revenues. Not like we do here. I've got $100,000 of revenues, I've got real estate taxes, I've got insurance, I've got some management fees, and then I pay tax on the net. In the US, the fallback position is that you're paying tax on the gross, unless you take a position of filing on the net with a W-8 ECI, that stands for Effectively Connected Income for a business. So those that don't do that get a nasty surprise at the cash because they owe money on the gross. Also be careful in which state you're operating in. Florida is very particular because it doesn't have income tax. There's only, 6 other states, and I doubt anybody wants to be in Alaska for investments or winter vacation. So that doesn't leave many states that doesn't have tax. And all the numbers that I've just discussed are on the federal line. So when you're going into places like New York, for instance, or California, you're pretty much paying Quebec taxes. And so it becomes extremely important to match the tax credits. Otherwise, I mean, California at the highest rates, you're looking at 48%. Quebec, we're at 53%. If you don't do your math properly, you could have more tax than revenue. So we have to be extremely careful on that. What happens when you rent your property? Obviously, tax filings need to happen on both sides of the border. The famous T1135, which is a document a lot of Canadians and accountants forget to file. It was at one point a personal use property. No need, there's an exemption on that. But then it turns into a rental property, and we forget to file a T1135. If there are any accountants in the room, we all know there's a minimum $2,500 penalty per year for missing that form. It could get very expensive. The use of the depreciation and recapture mechanisms is mandatory in the U.S. when your property is rented out. You absolutely must depreciate, and the formula is 27 and a half years. In Canada, you can depreciate on an elective basis, and you can't depreciate below zero. In the U.S., since you have a mandatory and a base formula, you're typically depreciating below your cash line, effectively creating operating losses. Unfortunately, the treaty doesn't allow us to use those losses here unless you have passive income gains. But what you need to do is you need to figure out a way to depreciate as close to the baseline on both sides so that when you go to sell and you get recaptured, you have a similar cost basis. So a lot of people don't do that. People don't even know they need to depreciate, and it becomes a problem. So you need to file taxes. You also need to get a tax ID number. Those were given very loosely in the past years. You practically can't get one today. So you want to make sure you do things right, you file properly, you take the right exceptions. Otherwise, it becomes trouble. One thing people don't realize also is that under the Internal Revenue Code, Section 1445, there is a concept called FIRPTA, Foreign Investment in Real Property Tax Act, which is basically a withholding mechanism on distribution of income or assets to foreign individuals. And in this particular case, a lot of people don't pay attention to that. They get surprised when the IRS or any accountant says that, oh, you've got distribution from a U.S. corporation, you're a foreign shareholder, or you've got distribution from a partnership, you're a foreign limited partner, 39% withholding on the income, you sold a property, 15% withholding on the gross sale price. People freak out. Quebecers forget that in Quebec, when a non-resident sells property, the withholding rate is 37.5%. But we always seem to be surprised. So we want to make sure you deal with somebody that's familiar with these things. A lot of people get the advice. They go to the U.S., they hear about LLCs. It seems simple. It costs $500 to set up. It's the magic one for no liability, easy creditor protection, flow through, and then we get to a problem. In 2015, the Canadian government came out and said LLCs, officially at a roundtable, said LLCs are no good. And in fact, it added to that bucket limited liability partnerships and limited liability limited partnerships and said those are no good at all. And the Canadian CRA gave a window of opportunity to convert on a tax-free basis, including currency exchange free basis, these entities. And typically what you would do is you wanted to go into a limited partnership. A limited partnership is the only entity that is treated identically the same way on both sides of the border. It's a flow-through on the U.S. side, it's a flow-through on the Canadian side, and therefore there's no double taxation. You can also, when rolling your personal assets into your controlled LP, you could do that on a tax-free rollover basis, provided you file the right forms in Canada. The U.S. doesn't care. They just want to know who the ultimate beneficiary is. So we've done a lot of these for clients. Today, unfortunately, if you've owned through an LLC and you want to roll it over into an LP, you're going to trigger a deemed disposition in Canada. Nothing happens on the U.S. side. For them, it's still the same beneficial owner at the end of the line, but nothing happens. Selling, same thing. A lot of people get caught in the FERPTA question. A lot of people get caught, what do we do? There used to be, the fallback is you sell a property, you're subject to that 15% withholding. That's the rule. A lot of people refer to the exception. There's a FERPTA exception. In fact, there's two of them. The first one is where the sale price is under $300,000 and the buyer agrees to sign an affidavit of personal use. We can eliminate the FERPTA obligations and there's no withholding. And even as a seller or a buyer, if you're asked to sign that document, you got law protection. If you sign the affidavit and your intentions at the time of signing are to occupy personally, and the sale price is under $300,000, you got law protection. You can sign that affidavit. The second exception is if the sale price is anywhere between $300,000 and $1 million, and the buyer signs that same affidavit, we can reduce the withholding to 10%. Now, the term withholding is important. Canadians think it's tax. It's just a withholding against your potential tax exposure. A lot of people think that if they leave the money with the IRS, they no longer have an obligation to file a tax return. A lot of people also think that if they were exempted from the withholding, they don't have to file a tax return. So we have to be very careful in advising clients about that. Last but not least, there used to be, or there is, not used to, but there is a process with the Internal Revenue Code to ask for a withholding certificate and basically telling the IRS, hey, look, we bought for $600, we sold for $600, we don't owe you any tax, so remove or reduce the withholding to the U.S. tax exposure. That process used to take 3 to 4 months. Today we're running about 14 to 15 months. So there's no value in it, and we recommend clients leave the money on the table and move on. So what happens in the U.S. For Canadians is that values of properties have gone up. The cost of upkeeping those properties has also gone up. And a lot of our clients are not comfortable, they want to sell. So we discussed about the issues associated with sale. You've got closing costs, you're going to have to pay capital gains not only on the value of the property, exchange rate, and you're going to have withholding. A lot of people will choose to generate some U.S. income by putting their property up for rent. And that's a pretty good strategy if you're comfortable with it. But you're going to have to file income tax returns, both in Canada and the U.S. You're going to have the depreciation and recapture mechanism. And more importantly, when you put your property up for rent, you're going to expose yourself to liability, tenant liability. You know, in Canada, you call your insurance broker, we bought a home or we bought a car, we need liability coverage. And the question is, do you want $1 million, $2 million, or $5 million? And what's the difference, you ask? And it's $20 a month per increase. You go to the US and you say, I just bought a home, and they ask you, do you want $100,000, $200,000, or $300,000? And you say, what's the difference? Well, about $1,000 per increment per year. And the reason being is the US only wants to give you coverage for what they're willing to pay out, knowing judgments are going to come at millions of dollars. And in Canada, we're willing to give you $5 million, knowing judgment is going to come out a few $100,000. So we have to be extremely careful on the liability side of things. So a lot of people, and thanks to Canadian subsidiary banks, are able to kind of keep their lifestyle, but go to a bank and refinance their homes. And if we take again that same example, we bought for $200, it's worth $600, you could actually take out your equity on a tax-free basis until the loan is paid back. And take that money, bring it back to Canada. And by pulling the money out of your home, the equity of your home, you've got zero capital gains. There's no tax to pay. And if you take that same money and you convert it into Canadian dollars, there's still no capital gains to pay. And then you take that money and you give it to your financial advisor, and he or she, let's just say, turn 5% profit on that money. And it costs you 5% to borrow today. Well, guess how much your cost of borrowing is? Zero. Because we have the ability to deduct the cost of our borrowing when we borrow for the purpose of reinvesting. So it seems to be a bit of a win-win to pull out your equity, let the money work while you're sleeping, pay zero tax until the debt is paid back, and still maintain your lifestyle and avoid all the pitfalls and all the traps. And what's great about most U.S. banks is that you could actually repay your loan at any given time with no prepayment penalty. So one of the big plays also is taking advantage of the currencies. The currency rate today is so high. So if you take it out, you cash it out at, call it 135, and for some reason the dollar drops to, let's say, about 120, well, you can repay that debt, trigger a small gain, but effectively turning your exchange rate overall on the purchase to 20% versus 35%. So there are some advantages in looking at financing or refinancing in the U.S. I'll spend a lot of time, I don't know how much time we have a few more minutes, I guess, just out of respect for everybody. I want to talk about U.S. estate tax for Canadians because I think that this is a topic that is grossly misunderstood in Canada and mostly by Canadian practitioners. Let's remember that U.S. estate tax is a tax that applies when a person passes away. For Canadians, it applies only if a Canadian passes away owning assets in the U.S. and those assets are worth more than $60,000. Now, what's considered to be a U.S. situated asset? Real estate, for one. Shares of stock of U.S. corporations, although they're held in your Canadian portfolio at the RBC, TD, CIBC, and so on, they're considered to be U.S. situs if they're in your name. Typically, those are the two things that are going to be your biggest U.S. estate tax pitfall. I often have clients calling me, Shlomi, I'm calling you, I just bought $1 million home in Florida, I'm really concerned about U.S. estate tax. And we look at the history of their assets, and they got $3 million in Apple shares. I mean, your problem started when you bought Apple shares. Don't worry about the condo in Florida, right? So let's first understand that the system itself is for U.S. situated assets only. Now, under the Canada-U.S. tax treaty, when a person passes away with U.S. situated assets, the basic mechanism is that the first $60,000 of U.S. assets are tax-free, and the balance is subject to taxation. So a general scenario, you own $1 million home, your first $60,000 is exempt, the balance is taxed at 40%, $940,000. Comes the Canada-U.S. tax treaty and says, if Canadians are willing to disclose to the IRS their worldwide assets, the IRS is willing to extend the same annual U.S. estate tax exemptions to Canadians as well. Currently, that exemption is $12.9 million US and will continue to increase all the way through 2025. The basic mechanism of that law is that it's a $5 million exemption indexed to the cost of living to January 1st, 2010 under the Barack Obama administration. And when Donald Trump came into power in 2016, he created a law in 2018 that doubled that exemption as well. So we're at $10 million indexed to January 1st, 2010. And with the cost of inflation in last year and the coming years, we think that by the time the law is to sunset on December 31st, 2025, we'll be around at an exemption around 14 or $15 million. What happens in 2026 is that Trump's doubling up disappears, and we go back to a 5 million indexed to January 1st, 2010, so we should be at half of 14.5 or 15 million. And that's per individual. What do we use to calculate your worldwide assets? Everything. Absolutely everything, including life insurance proceeds on your own life. So although you are not the beneficiary because you're unfortunately not around, that policy falls into the bucket of your worldwide assets. You got property in Israel or in Europe, that's included as well. And that's what we use to calculate U.S. estate tax. So the challenge is that everybody goes up in arms about U.S. estate tax. So giving you an example, let's play one. Husband and wife own a property together. They bought a property together, $2 million. Their net worth is $30 million. We look at it today, $30 million Canadian would be what? About 22 Canadian, US, give or take. Let's reverse it and say it's 30 million US. On the face of it, it looks like there's a 40% tax on $2 million. But under the treaty, where husband and wife own property together, you get a marital credit on first to die. So you actually get to utilize not only the deceased credit, but the wife's credit as well. So now today we're looking at almost $26 million US. So we went from a $800,000 tax bill on U.S. estate tax to probably maybe $200,000. Now, if we take the scenario where husband and wife bought that home for $1 million, and at the time of passing, the property is worth $2 million, we have $1 million capital gains in Canada. And that's 26.5%. Well, under the Act, we can actually utilize the federal component of that $250 or the $200,000 US of US estate tax against the Canadian or the federal portion of the capital gains in Canada, effectively slashing pretty much most of the US estate tax problem. So we get a lot of practitioners going crazy putting structures together. I see, tiered limited partnership structures. You have a Canadian limited partnership that owns a US limited partnership that actually owns the property, all this to avoid US estate taxes, and you run the numbers and you realize there's only $50,000 of US estate tax, but it costs you 50 grand to set up the structure, and it'll cost you 10 or 15 grand a year for the next 30 years to upkeep it. And guess what? You're going to sell it before you die, and there's no US estate tax. So if there's one thing I want to stress today about US estate taxes, it's absolutely something that needs to be looked into. It needs to be carefully analyzed and assessed before going into big structures. Another structure is doing the family discretionary trust, where dad puts in all the money. Dad's nowhere to be found in the trust. Mom is the trustee with an independent trustee. Mom's the only beneficiary. Maybe the kids are the beneficiaries. Then 21 years come and we got to transfer the asset out, so we give it all to mom. But mom has a U.S. estate tax problem because when dad dies, his will says everything goes to mom. So now mom has a U.S. estate tax problem, so mom says, I don't want it. Let's give it to the kids. And now mom and dad are in their 60s and they're now giving away their assets to the kids while they're alive. And in some cases it works. But in a lot of cases it doesn't work. Kids are still young. They're not married. Kids are still young. They're not very responsible with money. Next thing you know, I had this happen to us. Kid sold a house. 23 years old, sold a condo in Florida, got it out of the trust. Next thing you know, sold it and came out of the dealership with a brand new Lamborghini. That's crazy. What do you tell the parents? Sorry? It's too late, right? All this, so people put in place strategies for U.S. estate tax, and they don't necessarily work in their advantage. And most of the time, there's no need. So for me, it's all about looking at the tax, the estate planning, the needs, and coming up. There's another controversy about U.S. estate tax. A lot of people use limited partnerships nowadays to completely take the position that limited partnerships, a Canadian limited partnership is deemed to be an intangible asset. And if it's an intangible asset, it's not subject to U.S. estate taxes altogether. So for a couple of years, we had all these sophisticated structures. Now, a simple limited partnership works. I'm one of those people that actually thinks and believes that a simple Canadian limited partnership works. But a lot of the big accounting firms want to check the box on a limited partnership. So what is it? They create a big sophisticated limited partnership structure, costs a lot of money to set up. And then they take a filing position in the US that they want the limited partnership to be treated as a corporation. Why not just create a corporation? Right? So, and you go from 30 or 40,000 of setup fees and 5 or 75 or 10 or 15, depending on the accounting firm, and annual fees of upkeep to $1,000 a setup and maybe $750 a year, and you're going to achieve the exact same thing. What people don't realize is the U.S. has traps. It's very generous on extending opportunities to plan, but it also has traps. Anybody does U.S. tax here? No one. Johnny, maybe you know this, but Section 2036 of the Internal Revenue Code creates a trap of control. Anytime the code feels that an individual has any sort of control, any power of appointment, exerts any type of ability to manage or control the asset, it will impute the value of the asset to the deceased for U.S. estate tax purposes. It's large like this. So joint tenants with right of survivorship on first to die, for instance, Section 2040 of the Internal Revenue Code says that there's a presumption that says if husband and wife bought a property together and husband passed away first, his estate is imputed 100% of the U.S. estate tax liability, unless you can prove that the wife paid for 50%. You go prove that. Go figure a way to prove that. So there's a lot of traps that will enforce U.S. estate tax, but there's so many outs as well. There's so many ways to calculate to make sure you look at all the angles so that you're not necessarily creating U.S. estate tax planning where one isn't necessary. I see young people coming to me and says, I'm told I need this super sophisticated structure. I bought $1 million condo, I'm worth $10 million today. I said, you're 30 years old. You're worried about dying? Yeah, it could happen, absolutely. But you need to also manage risk. And with proper management, risk management, and proper planning, you can at very least defer or punt down the line the U.S. estate tax exposure. Very often you could eliminate it altogether. On our website, we actually have a simple calculator. If you go to levisalas.com, you'll be able to find this table. And if you plug in two numbers, your value of your U.S. situated assets and your worldwide estate, it will tell you what your tax exposure is. And often enough, you'll see that the credit is greater than the tax. And if you remember what I said today about marital credit and people in the room are married, then you can double up that credit versus the tax. And you'll realize that very often there's very little tax on first to die and sometimes even on second to die. So I don't like to necessarily go up in arms about U.S. estate tax. Just a simple example, a $950,000 condo owned individually by one person, $20 million worldwide assets in USD. You have a 39% marginal tax rate on the U.S. You got a $326,000 tax bill, but you have a $242,000 unified credit. Now, if this case was for a married couple, there'd be no tax. Now, let's assume that this property was purchased for $500,000, and the person dies, he's got an $83,000 U.S. estate tax bill, but he's probably got $400,000 or $500,000 of capital gains. There'd be very little or no tax at all when you utilize foreign tax credits on the federal side of things. So I don't like to panic about U.S. estate tax. I like to plan for it. I like to look into facts. There's very simple solutions for corporations, right? A lot of people have a lot of shares of stock. I remember there was a frenzy buying Facebook and Apple. Markets are not doing well these days, but those appreciate in value. A lot of Canadians are sitting on them. They've got U.S. estate tax trouble. What bankers don't realize is when a person dies and they get a copy of the will, and I think, Lindsay, you saw that where you were before. You get a copy of the will. He's got 3 million of U.S. shares of stock, and the initial incline is to say, okay, let's transfer it to the spouse. Well, if you don't have a clearance certificate from the IRS, the portfolio manager is on the hook for that U.S. estate tax. But it's a Canadian portfolio. It doesn't matter. So what we often see is we do Section 85 rollovers. You take that portfolio from the individual's name, put it into a sole purpose corporation or a holding company in Canada. Guess what? Company will never die. No more U.S. estate tax. So little things, spending a few minutes on thinking about solutions will save millions of dollars in a lot of cases. So I don't like to panic about U.S. estate tax. Investment properties are becoming increasingly popular for Canadians. I'm just going to say this. You have to be careful when you get involved into syndications. You have to be careful understanding your role in the overall structure. Most Canadians that do that in the U.S. nowadays are going to use limited partnerships, and in 99% of the time, they're going to be just fine. So if you have any questions, feel free to come see me. This is just for information purposes. A lot of people don't know how many days they can spend in the U.S. It's a very, very tricky thing. People don't know what to calculate. They don't know if it's a rolling year, if it's a calendar year. There is an immigration concept. There is a tax concept. I'll try to kind of take a minute, literally a minute about it. There's obviously two concepts. There's an immigration concept. Canadians, in theory, could stay as long as they want in the U.S. As long as the border officer doesn't feel that normal is the U.S. and vacation is Canada, it's up to them, and it's completely at their discretion to let you in or out. Why people speak about 180 days on a rolling year is because when we cross the border, we get a verbal I-94. An I-94 is really your entry, your B2 visa that says you can stay up to 6 months in the U.S. on that B2 visa. But since we get it on a verbal basis, if you are a UK resident and you walked into the U.S., they'll actually stamp an I-94 and it will say 90 days on it. Canadians don't get that stamp. We may get a stamp that says you got to leave by 6 months from now, but you don't get that I-94. And so I see a lot of Canadians spend 5.5 months, come to Canada for 2 weeks, and go right back. And the border officer is in a good mood. They'll let you in, and you haven't transgressed any laws whatsoever. But the general concept is you should not spend more than 6 months on a rolling year. Because typically, if somebody pays attention, they'll flag that you spend too much time. There's another reason for not wanting to spend too much time in the U.S., and there's a tax reason for it. There's also a question of healthcare, your RAMQ, that expires if you spend more than 6 months out of the province. Now, a lot of Canadians, especially during COVID, were sitting there, couldn't fly back. They want to have to deal with COVID tests, vaccinations. So there's ways to extend your stay in the U.S. It doesn't fix the other problems, but it'll give you immigration possibility by filing a 539. I-539, which is an extension to your visa, your visitor visa. But, by the time you get to it, it could take about a year. So people that want to stay a bit longer will purposely file an I-539 and stay an extra month or two, and provided that you filed it before your visa expired, your 180 days expired, you're legal. You're not in unlawful presence in the U.S. And once you walk out, the application pretty much becomes void and you move on. The other problem, however, is a tax problem. And I think this one is a little bit more complex and more important to pay attention to. Any Canadian that spends more than 182 days a year in the U.S. will be considered a U.S. taxpayer. What does it mean? It means that your worldwide assets are now subject to U.S. taxes. And since certain rules apply differently, there may be a serious exposure to double taxation. One very important one is the concept of PFIC, Passive Foreign Income Corporations. If you're considered to be an American taxpayer and you have a holding company that generates passive income, that company from a U.S. perspective isn't eligible for retained earnings. The company is deemed to have distributed the retained earnings to the taxpayer in a given year. And so if you made $1 million in your corporation, but only withdrew $200 in Canada and left $800 in retained earnings, Canada doesn't care. But the U.S. will consider that $800,000 given to you and taxed in your hands, typically at 37%, which is the highest marginal tax rate. Now, the U.S. has a funny way to calculate U.S. tax residency because it's not a clear-cut 182 days over a calendar year. It's rather the substantial presence test that takes into account a formula over 3 years. The number of days you've spent in the U.S. for the current year, 1/3 of the days you spent in the U.S. the year prior, and 1/6 of the days spent in the U.S. 2 years prior. If we take a very standard traditional snowbird that spends, let's say 6 months a year, 180 days, so we got 180 plus 1/3 of 180 is 60, and 1/6 of 180 is 30. Put it all in a blender, the number that pops out is 270. Well, guess what? 270 is greater than 182. Welcome to the United States. You're a taxpayer. And now you got to deal with all these issues. Come the U.S. tax treaty, Canada-U.S. tax treaty, and say, well, if you are in that situation and you want to extract yourself from the substantial presence test, you can file closer connection form, Form 8840. And what that does is it says, although according to your, and I say it, quote, Mickey Mouse formula, I am 270 days here in Canada, I'd like to take a position of closer connection and remain a Canadian taxpayer. Now, those that go over 182 physical days in the U.S. could still take treaty-based positions by filing Form 8830, and the form will allow you to still remain a Canadian taxpayer provided you fall into the treaty-based tie-breaking positions. But you have to worry about healthcare. The minute you spend more time, you lose that. Most people are going to go under the radar, but in some instances, when it's high-profile clients and you're deemed to be a U.S. taxpayer, Canada may also, and I've seen it happen once, and it was a high-profile client, but Canada may also take the position that you're deemed to have departed Canada for tax purposes. And for the accountants in the room, you now have a departure tax liability. And I'd like to say that when it comes to taxes, you better be, I'd like to be proactive, and I'd like to get caught flat-footed with too much planning rather than to getting caught flat-footed with no planning at all. And if Canada deems a high or ultra-high net worth individual departed from Canada, a tax bill is very salty. And if you don't plan for it, and if you don't put mechanisms to defer the tax payments, it's a problem. So I'd say careful, consult with a cross-border advisor. Again, our firm is uniquely positioned to be able to help. And so if you have any questions, you need to ask us questions, you want a consultation, we'd be very happy to provide any one of you or your clients with free consultations. And with that, I'm going to say thank you for attending. I am available for questions live or after. Thank you. Any questions?
First of all, thank you very much. Very informative. On the U.S. tax, the estate tax, if I understood correctly, so the estate tax concerns the beneficiaries of the deceased whose estate is being distributed.
Correct.
What if it's a Canadian person who has significant holdings in the U.S. and the beneficiaries are U.S. citizens? In that case, the U.S. kids who are citizens would be subject to the U.S. estate tax as well, correct?
Well, the tax is payable by the estate. So typically your beneficiaries will inherit tax-free. So they're not going to have an issue. Okay. But if you look at significant estates where parents pass away owning some U.S. assets, are subject to U.S. estate tax, but their kids are Americans and they fall into the bucket, we may have a much bigger problem because for Canadians, only the U.S. situated assets are subject to U.S. estate tax. For American, the American child will have to deal with taxes on their worldwide assets from a U.S. perspective. So I'll give you an example. A Canadian dies with, I'm going to use big numbers, $50 million U.S. worldwide assets and $1 million condo. His worst case scenario is 40% on that $1 million condo. If that same scenario, the person is an American, the U.S. estate tax is on $50 million. So they'll get the 12 and the 13 million exemption, but then the 37 million is going to be taxed at 40%. So wealth transfer needs to be done very uniquely, especially in Canada. When you have a Canadian family that has U.S. beneficiaries, their estate planning here should be ironclad so that you can transfer the assets and not subject your kids to U.S. estate tax on Canadian assets. So, parents say, over my dead body, will the U.S. tax my money? Well, guess what? They will, right? If you're not careful.
Thank you.
Any other questions? One in the back?
You talked briefly about investing in the U.S. and people are doing limited partnerships and syndication. For a Canadian, what's the best way to invest in a syndication in the U.S.? And if you take it one step higher, if the Canadian is part of the syndicators, how should the structure be set up?
I'm going to answer you with, just like a good lawyer, I'm going to answer you with a question. Where does the money come from?
Mostly U.S.
No, but is it personal money or corporate money?
The syndication?
Or the investor?
So the Canadian is probably going to be putting in from a corporation, and the U.S. people will probably be putting personal.
Right. So the U.S. people are going to come and say, we're looking for liability protection. We want to use an LLC. You're going to say, I'm using a Canadian corporation. If my Canadian corporation has direct ownership in an LLC, I'm going to get double taxed. Unless I use the LLC as a blocker, but now I got to tell my U.S. friends that the LLC needs to be treated like a corporation. They don't like that. So I'd say that just off the cuff, not knowing more, your best go at this is to have a structure where in the U.S., the syndication project is handled through a U.S. limited partnership. In fact, multi-member LLC is taxed as a limited partnership on the U.S. side. So the minute you have more than one member, it's already treated as a partnership for tax purposes. So I would probably create a U.S. limited partnership where the general partner is probably an LLC. The Canadians should have no involvement with the general partner. That's where the syndication problem becomes iffy. If Canadians absolutely want to have GP status, then the GP should be a corporation, a U.S. corporation. And then what happens is that the limited partners could be a mixture of all kinds. You could have U.S. individuals that could own their share through their independent LLC, although it's putting a Band-Aid over a Band-Aid. So they can own it through their LLCs or individually. You can own your shares through your corporation. And what's great about the limited partnership, it will flow through tax-wise to the membership pursuant to their tax obligations. So you'll pay corporate taxes. The individuals will pay individual taxes if there's trust. And so everybody will have their own individual treatment.
It gets complicated if the Canadian wants to be a GP, you're saying?
I think so. Well, you're just going corporate. But you got to remember that in order to do that and becoming a member of the GP who assumes all the liability, you also have to figure out a strategy to make sure that the investor isn't going in with a corporation full of assets. Because something goes wrong, the GP's on the hook.
Okay.
So there's very, very lucrative, but also very risky.
I guess I got to call you.
Maybe. Yeah. All right. Thank you so much for coming. Drive safe. Oh, you have a question? Oh, he has a question. Look at that.
Unmarried couple, been together 10 years in Quebec. That's common law. You pay taxes together. One spouse is American with Canadian residency. The other spouse is Canadian. No property in the U.S., but if the Canadian spouse passes and leaves everything to her partner who's American, what is the tax liability and what are the pitfalls of inheriting, being the executor and the beneficiary of the deceased Canadian?
I got to tell you, that's an excellent question. I think I'm going to tell Shirley, we need another session just for that question, actually. So most of your question, I would say, is actually moot. Nothing to worry about. The deceased's estate will pay tax in Canada. The partner in the U.S. will inherit it tax-free. If the assets are significant enough that they may put the U.S. beneficiary at a potential U.S. estate tax exposure when she passes away, there could be some planning. But I think the most important part of your question is about having a U.S. taxpayer or a non-resident as an executor or liquidator of a Canadian estate. And here we're opening up a huge Pandora's box that, you know, if I had a simple piece of advice, is find a Canadian executor for the estate.
The daughter is dual citizen. Same problem?
Better, but not perfect. So better from a Canadian perspective, but still a mountain of compliance issues on the U.S. side. I'm going to say this. There's a bunch of trust companies in Canada. Royal Trust, TD Trust, BMO Trust, National Trust, Scotia Trust, you name them. And these people are trained to act as executors on estates. And mostly for people in this example, best would be to stay away from any non-resident being involved in a settlement of a Canadian estate. The biggest problem I see is the 116 withholding that will just take 40% of the assets and freeze them every time an asset is sold, stock is sold, real estate is sold, it's still going to go until the estate could file taxes, get a clearance certificate, and it puts a burden on the beneficiaries.
Thank you very much.
Thank you so much. Great question, but I'm going to, next time I talk, I'm going to bring you with me. Thank you so much. Have a great day.
La philanthropie détient le pouvoir de transformer des communautés entières et d'améliorer de façon significative la vie de millions de personnes. Un simple geste de bonté peut avoir des répercussions considérables sur la vie des gens. La Fondation communautaire juive de Montréal est fière d'inaugurer le Centre d'apprentissage philanthropique. A groundbreaking initiative that brings together professionals, donors, and charities to create a better future for generations to come. We're excited to have you embark on this journey to change the world through philanthropy. Over the next 12 months, we will invite you to highly curated events designed to inspire and give you the tools to reach your personal and organizational goals. Philanthropy is about coming together, making a difference, and shaping the world we live in. When you join the Center for Philanthropic Learning, you'll be part of a movement of people who share and care. That's smart philanthropy.